Good evening, everybody. Welcome to the third lecture of the Hersch Lauterpacht Memorial Lectures for 2024, titled The International Borders in an Interdependent World, with Professor Beth Simmons from University of Pennsylvania. After demonstrating the growing importance of borders, Professor Simmons made yesterday a powerful argument for viewing borders not as lawless areas of national security, but instead as collective institutions that must be regarded and regulated as multilateral public goods that serve the common interests of the international community as a whole. State must envision their borders, and international law must envision borders as part of state responsibility as good neighbors to their immediate neighbors and to all other states. That's a very promising proposition that I'm sure we'll hear more about tonight. Thank you.
Thank you. Thank you very much. It's nice to see familiar faces. Thank you all for coming back. That means it's gratifying to see that some of you have returned several times. And so I really very much appreciate that. I have just a little bit of an outline to show you, to sort of try to plan out what I want to say today. And this is, of course, the most difficult part of a lecture like this, isn't it? Because it is one thing to theorize these things, and it is another thing to see if one can say anything at all useful in terms of trying to think about the literal governance of these spaces on the ground. And so I want to cover a little bit of area here that will clearly sound familiar. In terms of sort of thinking what we should try to make a project of proper border governance look like. I'm going to talk about some things, some roads that I do not intend to take. One is the idea of border stateism, despite that I've given you a very state-centric kind of an approach. That is kind of the rights and responsibilities in some ways of states. It's sort of the project of states is to border. I'm going to at least flag that I think a lot of bordering must take into account developments on the ground. Local communities are affected, and this is part of what absolutely must be taken into consideration as well. And then I'm going to also suggest why I'm not a fan of border abolition. So this is, so I'll explain kind of what that means, what some of the roots are, but it's the proposition that somehow we can get rid of international borders. And I don't think we can do that. I'll say just a little bit more about that in the conclusion as well. I just don't think that's where we can go right now. And then I'll talk about the most important thing, that if nothing else, I'm hoping that becomes clear at the end of this whole 3 days of giving lectures, and that is we need to at least reverse the presumption that these are areas of exception where human rights states have no responsibility as far as, or very little responsibility as far as international human rights go, that in fact there are strong reasons to believe that that presumption should be reversed, precisely reversed. And then I'll talk about ways in which we could think about halting the hardening. And I don't, I'm not going to make myself to be a completely open borders person, but borders have to be constructed humanely. And to the extent that they're extraordinarily hard structures, and I mean that both in kind of the strategy of trying to control them and the physical structure of trying to control them, we are dangerously close to violating international human rights in these spaces. So that needs to be, I think, completely rethought. We should find ways to think about these spaces as more porous spaces with strategies that do not have such a militaristic kind of flair to them. And then I'm going to sort of think about another problem we haven't really thought of, but if we're at liberty to think about border regimes, another thing I want to think about are these spaces just a little bit in the world where it's not a matter of defending the border, it's a matter of the black hole that can emerge when the place is not properly governed at all. It doesn't fall within borders. And I think there are a few things to say about that too. So that's when I want to discuss this issue of minding the gap and talk a little bit about objective regimes and black holes. I mentioned this very briefly, the idea of objective regimes yesterday. And see if there's anything more that we might want to say about that when we think about governance of areas and where it's not quite clear. Who's got responsibility? If no one's got responsibility, then you know what? No one's got rights either, because they're very difficult to claim. And then finally, I'll be drawing some conclusions. So I didn't, just to sort of get us started, I guess I would like to sort of begin by saying that we're a little time constrained in dealing with the difficult issues. There are 317 international land borders in the world. 25% of the world's population lives within 100 kilometers of them. 36.4 million people live outside of the country that they were born in. And there are 300 million people this year who will be claiming or are in the midst of processing claims to migrate internationally that are in the process of migrating internationally without documentation. And over the years, 143 million people are likely to be uprooted in the next 30 years. 143 million people are likely to be uprooted by rising seas, drought, searing temperatures, and other climate catastrophes. And we have, 55 minutes now. So no pressure here, right? To see if we can say something that is just the least bit, speaks to some of these very serious and mounting problems. These problems are not going to go away. They will only intensify over time. And I'm going to admit right off the bat, there's no way to do justice to all of this in the time that we have here. What we face is a situation in which there's growing border anxiety around the world, border hardening, and narratives of border sovereignty increasingly being used around the world. And not only that, let me just add sort of one other thing, just from my political perspective. Now we're talking about human beings that do not have very clear advocates in the world, like we do domestically, right? You can sort of imagine that your fellow citizens maybe have a right to enjoy law. You can imagine your own rights might be at stake domestically. But when we're talking about this vulnerable group of people, we're in fact talking about the group that is almost nobody wants to seriously advocate for. And so I think that's another thing that we definitely need to keep in mind. And yet there are some resources in international law to at least begin to think about these things. Treaties. Treaty law has shown us that international borders actually provide some reason to believe that states are willing to give up some pieces of their consent and sovereignty for a common good. Historically, the common good is stability. There are general principles of law and good neighborliness that we can draw on as well. There's an obligation not to exercise prerogatives of sovereignty to harm a neighbor's interest, or obligations to adopt sets of border rules and routines that uphold international community values like fundamental human rights and a right of non-refoulement. So there are positive and negative claims in this area. So we should be keeping that in mind as well. When I use the word border governance, I think of that as ways to realize the principles of international law in the ways that states are structuring their relationship. I'm talking about now structures on the ground, legal structures that states negotiate between themselves, practices they adopt. So this could be adopted bilaterally, regionally, even unilaterally. I'm talking about these kinds of practices as well. And it seems to me that we're talking about all of these practices and sort of ensemble of agreements that states might come to as being a way to realize the general principles I was talking about yesterday. So that's what I'm going to be trying to talk about today. There are ways forward here that I would like to sort of touch on. First, the idea of flipping the script. An urgent need exists, I think, to resist border exceptionalism, and we need a credible alternative to that. Okay, so you can't just wish borders away. We need a credible alternative to a more sovereigntist understanding of international borders. And I've argued that we should be reaching for the cooperative roots of bordering as a cooperative institution. We should be looking for neighborly routines as well, border practices that respect the international community's interest in bordering, and we should be minding the gaps areas where international law doesn't seem to be reaching to protect human rights because of the way borders are configured. But this creates areas of exceptionalism in a different sense where human rights don't seem to be able to be realized. So let me talk just a little bit now about these roads not taken, choices or directions I don't think we should be going. The first is this idea of border statism. And despite the fact that states are responsible for national security, they're responsible for negotiating their borders, every responsibility I've been talking about here, I've been sort of thinking of in terms of neighboring states, essentially. But I think it's really important that I at least flag to this group that I have very much in mind, thinking about the needs, aspirations, hopefully the participation, but not always, of domestic groups on the ground. Okay, and it just seems to me there are good reasons to do that. And mostly these are kind of practical and normative reasons. There's not clear legal international law reasons so clearly, although I'll touch on one, but local communities, after all, are at the front lines. And it seems to me you sort of make it out to be a little bit of a hopeless task if you don't consult and figure out what their needs are, what their concerns are, what their fears are, how they might try to frustrate some of the projects that might be going on. It's very important, I think, to understand that. They experience bordering on a daily basis. So it's crucial, I think. And studies have actually confirmed that a lot of reciprocity and cooperation at the border is at the very local level, where officers get to know each other and officials sort of iterate their back and forth on a sort of a daily basis, and then a certain degree of routinization, maybe even trust, builds up. So it seems to me that the local level really is very important. And I would point at least to the existence of some jurisprudence that suggests in the bordering space that local conditions, opinions, and needs do matter. And let me go back to the example of kind of where borders are drawn. And just to sort of look at a couple of cases, there's a growing jurisprudence that listens to the locals a little bit as well. So if we cast back just for a moment to the period of decolonization, and we look at the rules that the ICJ tended to apply in decolonization, it was very clear that Oedipus Idatus was the dominant approach. Absolutely clear, it seems to me. We can get this from the frontier dispute involving Burkina Faso and Mali, of course, in 1986. But more recently, there's been more attention, more concern, at least more notice given to so-called human-oriented goals that are held by groups on the ground. I think some of this is very practical. It's because if they're unhappy, don't have access to resources, don't have access to their kin on the other side, you're going to run up against a real problem. And so there are areas in some of the decisions that more recent tribunals have made that touch on this. And this is I got this sort of tip off on this. One of the students actually of Professor Benvenuti, who is it Michel Lauterpacht. Yeah, and I found this to be a really interesting article because this article showed how ICJ decisions increasingly give a nod to local conceptions of equitable water access, for example, now in the 2013 Burkina Faso Niger case, as an example, or the needs of local nomad populations that were considered in the border arbitration between Sudan and South Sudan. So the principle that people on the ground matter and should be taken into consideration when bordering, I think there's some reason to think that there are some principles there that ought to we should take on board, and that I think would justify sort of being very careful to consider the local perspectives on the ground. And how ironic it would be not to take this jurisprudential trend into account in border governance, it seems to me. And part of the reason is, bordering is considered such an urgent matter. Security is at stake, that so many times you see their interests run roughshod over. Let me give you just one little example. I know I draw a lot from the United States, but I just need to give you this example. So when the border wall was built in the United States, there were a total of 26 laws waived that would have given local input. I love to show this picture, not because you can read it, but because it shows every one of these squares is an instance of which law was waived in which sector of the border. They are environmental agreements. They are agreements to recognize the cultural significance and archaeological heritage of particular areas. These were waived, meaning no hearings, no input from the locals. And it strikes me that in the rush to expedite building and to securitize borders, we risk marginalizing those whose lives are going to be impacted. And I just wanted to flag here that there are real people on the ground that live with the consequences of the nature of the bordering that goes on. There's even a Supreme Court case from Israel that I really have a lot of admiration for, in which the Supreme Court, in the case of the Beit Surik village, came up with this very appropriate phrase that the fabric of life of the entire population could be affected by where the border fence or securitization is placed. So I feel like this is something we need to keep in mind. And I'm hoping that as we think about border regimes or border governance, that we do keep those sorts of things in mind. Let me say now something about border abolition. And I want to say this because this is an opposite trend to the idea of having too much statism in the border. It's the idea that borders may somehow disappear, that they should be hoped away, that they should be abolished. And this is a view of international borders that is part of a broader view of the way the world works. That the world is essentially a hierarchical, subjugating setting, and it replicates inequality whenever these kinds of structures are put in place. They simply replicate the inequality that we see. It's a example of reproducing racism and oppression through controlling human movement. And this movement of border abolition, I think, is related to some other movements. I think that, one that is starting to get a lot of play in the United States is prison abolition, for example. And the idea that we incarcerate too many people in the United States, that it replicates physical control. It's very racist in many ways. And there's a move afoot to really kind of bring up that question. This is related to that sort of point of view, and probably around much of the world it would resonate with a lot of neo-colonialist thought in this area. And let me just say that I have a lot of respect for having attention drawn to this. Okay, so I really do, and that's why I would bring it up here at all, because the abolitionists are calling on us not to fiddle around the edges. They're really asking us to take inequality very seriously, to cut to the core of the problem, and to overturn the structures that perpetuate inequality. And I think it's a crucial insight that we absolutely have to keep in mind. The world is riddled with inequality from top to bottom. And I would only rejoin that international law as we know it has relatively little to contribute to the abolitionist project, okay? So it seems to me that if we want to say what tools does international law offer us, that we would be better off perhaps reaching for the tools of international law and say, how can we make bordering better? How can we achieve something through bordering in a way that can preserve our other values that we're interested in preserving? And I have much less inclination to destroy the territorial state than to try to hold it much more accountable than it's been held in the past. So I wanted to put that out there. And yet I definitely feel like it's a perspective that I have some respect to be reminded of this. I think that's a very good thing to be reminded of. So let us turn now to the third point I wanted to develop a little bit now, getting more into the meat of what can be done here. What would border governance look like? And the first thing I think it would look like is almost just a simple extension of what I've been saying, is that we need to use the lens of international law and what I would call the cooperative law of bordering to reverse the presumption of exemptionalism in these regions for human rights. So the law of treaties, I think, already gives us just a little bit of standing here to make the point that there's an international interest in the exemption of pure sovereignty and pure bordering right? This is the area where the exception is in treaty law. It's that you don't have the unilateral, justification, essentially legal justification for unilaterally changing your borders. There is one exception to the idea that treaties are consensual. And that area is always around this kind of bordering and territorial kind of question, bordering questions. Valid border treaties cannot be terminated at will. Valid border treaties essentially run with the land and are the only exception to this clean state rule when we talk about the law of state succession. And it's a testament to the collective interest at stake that treaty law has already flipped that script. And I think we need to do that much more broadly and apply it to the exemptions of human rights as well. Now, how can we do that? The first that I want to talk about is that we really do need to carefully scrutinize national security claims. Who's we in that sentence? That one starts nationally, okay? So that one starts with the willingness, for example, of courts to take a careful look, even other groups that are willing to try to, sort of really try to get states to explain what it is that is in the national interest here. I think these claims need to be scrutinized, and there may be other settings. There may be other judicial settings in which that's appropriate to do that as well. But this would help us, I think, to reverse the exceptionalism at the border and to stop and then reverse the legal exceptionalism that sort of exempts human rights in these areas. Probably there's a lot of heated rhetoric during the past decade on the presumption that border zones are closer to war zones than they are to neighborhoods. And I just think we have a responsibility to sort of say, how so? What's the evidence? And that should be done as transparently as possible, because not every human encroachment over a border is a national security issue. Of course, sometimes they are. Okay, so sometimes they are, but the presumption ought to be the other way, that generally speaking, they're not. And we should be encouraging and training border control agents to see migrants as neighbors and displaced persons as vulnerable persons in need, and asylum seekers as persons exercising a right guaranteed in international law rather than as threats to national well-being. I don't think reversing this presumption is going to solve anything like all of our problems. But if you don't start looking at a problem differently and demanding evidence of claims, it seems to me it's going to be very difficult to try to persuade those who need to hear a message like this, that there's a need to justify these claims of national security. It involves a sober fact-finding and transparent assessment. It's very important because in so many areas we see the national security creep, the state going on in a lot of areas. Oh, we need to control TikTok. Oh, we need to control, and maybe. But the state has a way of creeping more and more in the national security space and making claims that I think need to be justified. Now, obviously, well, I guess I should say one other thing. It is harder to make this claim that I'm just making persuasively because there literally have been some national security border crises that have been so front and center. So it's going to, it's not an easy case to make that we need to flip that script right now. But, those are cases where there truly are national security issues at stake. So I want to acknowledge that. So I think one other interesting thing is that, some states do face these risks and many states think they do. Okay. I thought it was interesting that there are 76 countries in the world whose military and militarized security forces have border duties. So we have a lot of militaries at the border, not just police, not just customs officials, not just immigration officials. We have a lot of military forces in the world massed near borders or under command of a true military structure. And even in countries where the border is not fully militarized or under the military, there is a tendency to see a lot of weaponization that looks awful lot like a military. So this is the United States southern border again, and that is very much what a U.S. military officer looks like when they're going into battle and when they're entering a combat situation. So they're equipped with weapons of war during migratory surges. Okay, so you're asking for some sort of sense of license to use the power that we've been endowed with to take decisive action. And the importation of concepts that we've talked about already, the very concept of deterrence, or the idea that it is possible to strike back so hard or to make the crossing so uncomfortable so as to discourage border crossing in the first place. So it seems to me that we need to be a little bit careful about, we need to scrutinize, I think is the better word. We need to scrutinize the nature of militarization in these zones as well. And what I think actually is that scrutinizing more carefully these claims of national security will do two things. First of all, it might very well turn up a better assessment of the security risk. Right? You might discover some things that you should have kept your eye on, perhaps, if we were really careful about this, but they need to be separated as clearly as possible from other kinds of crises like humanitarian crises. So there's a double benefit in my estimation, that you could benefit the quality of national security decision-making at the same time that you could prepare yourself better for the possibility that these are, after all, unarmed civilians facing a humanitarian crisis. Yeah, next thing I want to offer is, I don't know how you'll think about this, but the idea that, oops. That's in the way up there. Ignore that thing up in the corner because it's on the next slide too. I don't know why it got pasted up there as well. But the next thing I want to propose to you is that we should be thinking about whether it'd be a good idea to decriminalize, to encourage states to decriminalize simple entry, unauthorized simple entry. And so what this slide is showing us, if I didn't have this up here in the way, but I'm not going to mess with it just in case, is that out of 116 states for which data could be found on what their criminal law says about, or what their law is essentially around simple entry with no other commission of a crime. Okay, so just entering without being authorized. Of 116 of them, 109 of them can impose prison time as punishment. And out of 167, 116 criminalize entry, and out of those 116, 109 of them impose prison time. So that's already a very high proportion of states that have pretty stiff penalties. This is the one that was kind of superimposed in the last one. This is just a picture now of all of the rules in 126 countries for illegal entry, and these are the kind of the highest penalties in each one of these cases. So it gives you a sense that a lot of people get prison time for just entering, not for doing anything else illegal once they do. In about 109 would get a fine. There's some double counting here that you get both a fine maybe and a prison sentence, or maybe you might get either or. Deportation, very common. And then we also get some instances of some detention, public surveillance, labor, forced labor, community service, and then Malaysia and Singapore allow whipping or caning if you enter their territory without authorization. So it seems to me we should might be thinking about whether it would be a good thing to try to think of a movement internationally to develop a commitment that entry alone perhaps shouldn't be criminalized, or perhaps the penalties should be reduced. So why should we do this? I mean, there's a couple of simple policy reasons I'll throw out, but the real reason, of course, is going to be human rights. But criminalization is a waste of resources, which could be used in a lot of ways. So people get put into detention and it gets expensive. I suppose that's every state's prerogative to waste their money. So that's fine. But when the push factors are strong, this kind of deterrence doesn't even work. So a lot of what is occurring, for example, at some of the borders of the world, we know the borders of Europe, for example, borders of the United States, you cannot, the situation from which people are leaving is so dire that a little bit of prison time is just not going to make any difference to many of them. And the third thing I want to say is that criminalization is part of this rhetoric and mindset that sort of, again, is this kind of presumption of exceptionalism in a way. So, criminal trespass is one thing, but simple trespass is another thing. And it seems to me that we ought to be thinking of this as just a little bit more of a simple trespass rather than some kind of an aggregated or criminal kind of a trespass. But the most important reason of all is that criminalization risks and raises the risk of serious human rights violations. And it's a simple proposition, all other things being held equal, that the longer you are in the detention of the state, the greater the probability, all else equal, that you're going to experience some pretty serious human rights violation along the way. So the greater the chances of inhumane treatment or maybe even torture. As I was talking about the report of the special rapporteur on torture, who gave a very clear assessment of the kinds of things that migrants in detention endure. Separating young children from their parents in order to prosecute them constitutes, I think, family separations that violate fundamental human rights. Labeling a border crosser a criminal is a signal to state authorities that they are dealing with a real threat after all. So there's a phrase in the United States that was a lobbying expression of the gun lobby. Okay, so guns, big deal. They Second Amendment in the United States. Everybody's got a gun, and the effort to abolish guns ran up against this claim that if you make guns illegal, only criminals will have guns. Okay. If you make crossing the border illegal, the only people who cross will be criminals. You've defined them as such. It is a self-fulfilling kind of a prophecy. And these are the conditions, I think, that give rise to very fertile grounds for violating human rights. If you believe you have a criminal in your possession, it is a license to perhaps treat them a little more roughly, keep them a little longer than perhaps you would have done otherwise. So just a thought there, but in very soft and quiet terms, decriminalization of unauthorized entry merited a gentle but explicit mention in the 2015 New York Declaration for Refugees and Migrants. And I never noticed it before. So I sort of went back and kind of read it one more time and looked closely and said, they're recommending that states, where states parties have declared their willingness to consider reviewing policies that criminalize cross-border movements and pursue alternatives to detention while these assessments are underway. So this is something the international community has thought about. And why not? Does it feel to you like they're meddling in domestic law, domestic criminal sanctions somehow, and they don't belong there? Does it seem like that's an illegitimate thing for the international community to be doing? I say no. I say no because international law has been insinuating itself into criminal codes now for a long time. It's just that it's always, almost always been in the opposite direction. In fact, one study by Bassioni noticed in 2016 that there were some 281 conventions passed between 1850, so it's a long time, and 2005, with criminal provisions in them. So, this is not off limits for international law to be thinking about what the appropriate role is of criminalization. And if there was a good reason and a consensus to that this would actually help to address a problem of mistreatment of migrants who, after all, other than crossing the border, have not committed a crime, then it seems to me like this would be fair game for the international community to perhaps make even stronger efforts and recommendations along these lines. But decriminalization for the mere fact of having crossed a border without permission, it would run counter to history, right? Almost everything's in the other direction. But I think it would go far to reversing the presumption of hostility that we see at international borders. So, moving on from that. Now, let's talk about halting the hardening a little bit here and softening the border. See what can be done along these lines. If we can reverse the presumption, the borders are always dangerous places, and the border crossers are always criminals, then the next logical step is to act on the international obligations of good neighborliness in this space. Obligations of neighborliness, both negative and positive. It's to our immediate neighbor, the neighbor next door, as well as to the international community as a whole. It's been generalized of the United Nations Charter and other declarations of the United Nations. So the obligation is to conduct border policies in ways that meet or exceed international legal standards and norms. So the first step, in my view, is we have to ditch this policy of deterrence. We have to do this, it seems to me, which doesn't mean we can't do border control, and it doesn't mean we can't punish people. But we can't threaten human rights violations. That ought to be off the table, actually, to threaten human rights violations. You know, it's clear. I was trying to figure out, is there a legal principle behind this? I'm not sure. I know that there is a legal obligation not to threaten the use of force. That's pretty clear. But what about threatening a violation of human rights? You know, it seems to me that there ought to be, maybe somebody knows, maybe you'll come tomorrow and show me what addresses that or not. But it seems to me at least that general principles of law, duress, for example, threatening. And it seems to me that we could maybe depend on general principles of law here to suggest to threaten through the use of policy whereby it's quite certain you're going to get your rights violated. It's going to be dangerous. It's going to be a violation of your freedom. It's going to all kinds of difficulties we've been talking about, that these are presumptively that that should be off the table, threatening international human rights. So I think border exceptionalism has knowingly put human rights at risk, knowingly and purposely. Okay, so it seems clear to me. Intentionally forcing migrants into more dangerous journeys where the risk of injury and death has been documented to be much, much higher, and that's quite well known. All of these, I think, for example, these are things that have been associated with the zero tolerance policy of the United States at the border. Now, if we were to, just imagine for a minute, if we were to enforce domestic law with such threats, what would we call it? We would call it repression. I went to the political science literature, and there's a whole huge literature on repression. Okay, what is political repression? And it is essentially threatening bodily harm or other kind of sort of physical coercion to get somebody to do something that the regime wants you to do. Now, when we do that domestically, we call it repression. When we do it at the border, call it border control. And I think that should not be the case. Quite clearly, I think that ought to be off the table. But we do have other things we can do. Transparently communicate what the law is as clearly and transparently as possible, and invest in its lawful enforcement. So communicate clear procedures for gaining access, for example, to define and to respect the protections of people that try to gain access along the way. Invest in the legal structure to make fair and rule-based decisions in a timely manner. So that's what we ought to be doing, it seems to me, not sort of threatening that it's going to be painful and that it's going to be hard. And you're going to be in the slammer and detained for a long period of time. Seems to me not at all the right way to go. The second thing I want to say under sort of this ditch the deterrence is, we actually have some soft law here to build on. And I hadn't thought about this, but there actually is some soft law that probably because there is so much border exceptionalism going on that I hadn't thought to draw on. And that is, we have a series, they're a little bit old by now, that probably needs some serious updating, but we have a series of international declarations and soft law standards around policing. I never thought of that till I started to think what can be done here. And these are things like codes that, way back in 1979, the General Assembly, for example, passed the Code of Conduct for Law Enforcement Officers. They defined law enforcement officers broadly enough that should include border control officers. Anybody who can detain somebody is considered, in the name of enforcing the law, is considered a law enforcement officer under this code of conduct. And the code understands this, that all officers of the law, whether appointed or elected, who exercise police powers, especially powers of arrest or detention, are covered by this code of conduct. So obviously this would include, I should have thought of this, includes border control officials. This code of conduct, I think, would be a very good starting point for humane bordering. It forbids torture. It enshrines principles of proportionality in the use of force. And that's, of course, a core idea behind domestic policing. And it admonishes law enforcement officers to be able to report violations to the chain of command without fear of punishment or reprisal. So, these are some things that could be built on, it seems to me. Another international agreement, there are so many there are about 6 or 7 that I came across when I was trying to sort of excavate this area. But just one other that I'm going to mention is the UNODC, the United Nations Office for Drugs and Crime, basic principles for the use of force and using firearms by law enforcement officers, the BPUF. It provides that the use of a lethal weapon is only acceptable if the intention is to protect against the threat of death or serious injury. No threats, not sort of shooting, in ways that maybe you could injure or slow them down. Certainly not the case that I was talking about yesterday, where a child is running back and forth across them. These standards exist. And there are many others that I could touch on now. But why don't we think about it? I mean, maybe you have thought about it, but I hadn't thought about it until I was trying to say, what am I going to say today on the last day of this lecture? I hadn't thought about it. We've got these policing standards, but it's the exceptionalism around borders that seem to have sort of set them to the side. They speak to fundamental human rights and indeed general principles of law as well. So I wanted to sort of mention that was all under this umbrella of trying to kind of ditch the deterrence, essentially, and put humane strategies to the fore. The next thing I want to say something about is open architectures, because architectures enable, they prevent, they incentivize. There are ways that laws can be enforced, and there are ways that human rights violations can be carried out as well. So so architecture is obviously very important, and there's sort of, I can think of 2 ends of a spectrum if you want to think about it that way. At one end of the spectrum, states can choose to develop architectures that reflect norms of neighborliness. And at the other end, they can build barriers that literally do the opposite. So let me just give you an idea of one that I think is kind of an open idea. Okay, so one of it's not just leave your border open either. It's not that, but it's an approach that I think has some hope, maybe of being more cooperative and the more possibility of monitoring, perhaps, is the idea of one-stop border crossings. Now, what is a one-stop border crossing? These are routines based on legally binding treaties negotiated to govern local reciprocity about passage. The idea here is this is configured in a way that you don't have to they're not sort of separated. The 2 states' border structures are not separated. They're right next to each other, and they do their inspections together. Sometimes states will instead decide to kind of delegate it to the other. But in an ideal world, I think the better thing would be to have them do it together. Why? Because there's just another set of eyes on what's going on at the border. And it strikes me that might be a good kind of an arrangement for just a little bit more monitoring what states are doing one with the other. Now, there's no doubt that structures like this were mainly built for traders. Okay, this is a World Bank kind of idea. We're going to do one-stop borders, and they were primarily aimed at African countries who have very little resources, and why should we duplicate all this sort of border structure? So I understand that there's an efficiency rationale for these kinds of things too, and I fully acknowledge that. But I just want to say that when I was sort of looking around at what kind of review these structures get, it seems to me that there are some pretty decent models, at least that might be built on. One is South Africa's one-stop border crossing model. It calls for joint audits to ensure that human rights standards are met in these spaces. So at least it's kind of they're thinking along these lines. And the idea of baking it into some kind of joint kind of a architecture seems to me a positive development. Some of the assessments I've seen are actually pretty positive in ways that I would not necessarily have thought of. So I was looking at a review by Fair Planet, which is one of these kind of social responsibility organizations. And Fair Planet made the point that it was hugely advantageous to women to go through something like this. Women traders were afraid to approach like one kind of lone state official, or, they were afraid. They also were being kind of forced around some of these and sort of just going in the back country where they would face danger. And this actually has turned out to give them better access to kind of an efficient and safer way to cross an international border. IOM touts, the Organization for International Organization for Migration touts OSBs as well as more than a border. It's a gateway to progress. Okay, whatever you think of the IOM. But the other thing I was just noticing was that in Southern Africa, one-stop border posts have been built into agreements to try to liberalize travel generally. And so the Botswana and Namibia Accord on free movement between countries, even Amnesty International sees this as a step in the right direction. And especially, again, mentioning the advantages for women traders in these kinds of spaces. This is not the kind of thing, it's for a particular kind of border, a particular kind of issue. But the point is that sort of thinking a little bit more about the connective and thinking a little bit more about the potential maybe for some monitoring. Now, I'm sure some collusion could go on in the space too. That's possible. But putting two eyes on it perhaps just raises a little bit the prospects that there might be just a little bit more attention to how people are being treated at the border. So there's another end of the spectrum, of course. And these are the structures, border barriers that are long, solid border barriers, and these do have serious human rights consequences, which we've talked about many times before. The diversion effects, the signaling effect of building that kind of a border structure, it makes it essentially impossible for refugees to claim their legal rights to protection in violation of international and often domestic law as well, both. So let me just sort of make 3 points about this very quickly. I think it's a flawed approach to have a border wall that is solid and impenetrable under most circumstances. There are some social goods of the international community that would require sacrifice. If that kind of a structure is tolerated. There are general principles of law that ought to prevent it too. It would require states to, it's sort of like, think about this. Suppose that a state wants to build some kind of a border structure that's totally solid, doesn't allow any coordination or shared responsibility for governing that area. It's almost like, it seems to me there ought to be something like the equivalent in property law of having to bring your architectural plans to your neighbor and saying, is that okay with you, right? Or the planning board, yes, you're looking at me like we don't do this, but of course we do, right? We have to get approval of the neighborhood for architectural plans when we're talking about property rights. Now, I'm not saying that the neighboring states have absolute veto power. I'm saying the neighborly thing, the general responsibility, is to try to present and accommodate the concerns of the neighbor. And these are the kinds of things that I think are very, very likely to come up. I think one thing we should be thinking about instead are data structures that are a little bit more kind of have an opening in case of emergency, for example. Openings that are spaced at reasonable intervals so that under circumstances where there's a migration surge, they can be opened and humanitarian assistance can be rendered, and people can try to, in an orderly fashion, try to make their claims for asylum. And so this is, I think, sort of ideally, and there need to, by the way, it's not just a matter of structures, of course. Somebody had to open that door. So there's still human agency in these decisions. And wall construction, if we want to think about it this way, is in some sense, it's an allegory for other forms of infrastructure for access, like processing and decision-making claims, like the legal infrastructure to handle the claims. It's not just a matter of opening the doors. If what they're doing, that they're just sort of getting marched over to a detention center, right? You've got to have the other kinds of humane ways to deal with people, including people who are not granted asylum. So that's a big, huge issue, is what to do with folks who have not been granted asylum, who fail to qualify essentially for asylum in an opening country, which raises all the issues about agreements for return and that type of thing. But as a matter of governance, this approach, this kind of solid wall approach, is least likely to glean cooperation on border management as well. You know, if you really kind of totally blocked off your neighbor. You know, it's just easy to say walls, walls, walls. But it's not just the wall. It is the legal walls, the legal bottlenecks, really, is the better way to think about it, that make entry, a frustrating and ultimately a human rights denying kind of an experience. So it's not just a matter of walls. That's an allegory for blockage, essentially. Now, let me say one more idea. And I was just thinking about this. And I was thinking about, well, I haven't said anything about water. I haven't said anything about the problem of people who are dying in the Mediterranean, for example, or the Caribbean, or the sea that's just north of Australia. Okay, these are parts of the world, essentially, in which there are what you might think of as sort of black holes in the law. Places where borders are a human rights problem because they leave rights bearers adrift. Okay. It's a different problem. Border geography sometimes means that human rights are at risk because of legal black holes, and sometimes parts of the world that essentially people have no human rights. So just one picture is sort of thinking about the Mediterranean and the search and rescue sort of areas here, zones here. And what happened, of course, is when Libya stopped patrolling their zone, nobody was patrolling that zone. People were dying in great numbers in that area. There was no coordination around what to do there. And so it's a phenomenon, I think, essentially the legal black hole in areas that have claimed so many thousands of lives. And I think we have a little bit of responsibility to think about that bordering problem as well. Again, the Caribbean, the Timor and Arafura seas as well, you get a sort of a similar kind of phenomenon. Lack of jurisdiction in some regions creates plausible deniability for states who might otherwise agree that they have no responsibility, or might otherwise say they would have responsibility to search and rescue. If you don't, not there, not outside of my zone or that kind of thing. So the question is, what might border governance in this kind of a setting look like in the service of human rights? Now, I had an idea when I was kind of researching this idea of border regimes, this idea of objective regimes. And objective regimes sort of used a lot in the 19th century, so it's an old idea. Objective regimes, the purpose of an objective regime is to establish international legal rules in a specific geographic area or specific purpose. That might otherwise not be able to be achieved in the absence of creating some rules in this place. And I wonder if this idea of an objective regime could be helpful in governing areas that just fall outside of the jurisdictions of states, in places where states have important collective interests, right, to save the lives of migrants in this space, but they lack the legal tools and coordinating mechanisms to make commitments and to accept obligations and to share responsibilities. Now, objective regimes, what are these things? They're not a treaty. They might be based on a treaty, but an objective regime is sort of there won't be, and you won't find anything like the law of objective regimes spelled out in a full treaty either. It's sort of a way that international legal scholars have sort of said, let's think about how we systematize practice. And let's see if we can come up with rules for systematizing practice in spaces where the law is not well reaching that area, and that is in the interest broadly of the international community. So not just sort of doing as you please in a particular place. Okay, so what kind of areas have been sort of under this idea of objective regimes? Maritime access, for example, political neutralization, demilitarization, and the idea or the claim here that is controversial is that if a subset of states set up an objective regime for a specified area in the interest of all the international community, that it might have ergo omnes consequences, ergo omnes effects. So that's controversial, by the way. I mean, I found more articles that said, I don't think so, than I found that really sort of were persuaded by this. But I think I want to push it anyway and just sort of see where we can get on it. So what do we need to have? We need to have someplace territorially specific, okay, Mediterranean, established by states with a particular territorial competence, which the states have already demonstrated for a large part of the Mediterranean anyway, not all of it, and that's the problem, but for a large part of it. And that this regime, objective regime, would involve general interests, general concerns of the international community as a whole. And the idea then is to sort of make good law with a broader effect than just those who have actually consented to it. Now, that should make you cringe, first of all, because, historically, these regimes have been established by major powers to pursue their interests, for sure. That's the historical use of these things. But I would just add to that, since the 1960s, developing countries have also been gesturing towards the idea of objective regimes when they talk a little bit more about areas, again, beyond sort of territorial limits, like the deep sea or outer space. They've talked in the same kinds of terms that objective regimes are sometimes spoken about. So the other thing that I noticed is these kind of protective objective regimes have been actively considered for, of all things, shipwrecks. The Titanic. The idea is, well, there's a cultural and historical interest in the Titanic, and it's a final resting place for people, but it's in the high seas, and it's not an area where anybody would have the jurisdiction to keep plunderers out of it. But if the international community have maybe a general interest in trying to protect the Titanic, and the Estonia is another example, another ship that was wrecked much more recently. So sometimes those are spoken about as those could be under protective objective regimes. And indeed, the high seas, generally, they're regularly mentioned as one principal area where objective regimes might be quite appropriate in some ways. And so I would put this to you. If objective regimes can serve the interests mentioned above, why not the purpose of fundamental human rights in the border interstices in the high seas? Deaths in the 3 C's that I've mentioned, they result from how international law constructs sovereignty and human rights jurisdiction. It's a bit of a fluke in some ways, that these are areas in which there is such a gaping hole in jurisdiction, especially when a country like Libya is not upholding its piece of the search and rescue agreements that they've sort of made. You can imagine that an objective regime that had a way for the others to kind of work cooperatively to take over that area, or maybe even a country that's outside of this list here. You could imagine that kind of agreement filling a black hole that would then have hopefully some consequences that would be quite positive on the ground. So whether or not there are erga omnes effects, I guess I'm going to leave that on the table as I'm unsure about it myself. But it seems to me that the creation of a set of claims about common responsibility in the interest of the entire international community are potentially a powerful way of talking about a setting like this, in which there's a black hole that nobody seems to be willing to take independently and individually jurisdiction to do anything about, falling between the cracks, essentially. And it's not as though, and, even if you don't believe the erga omnes claim that this would create obligations for all, it seems to me it doesn't leave states quite as free to completely ignore search and rescue assistance in such an area. So it would put something new on the table that might raise the expectation that we all are going to participate cooperatively in enforcing a set of principles that are of interest to the international community as a whole. So let me just now wind up with a few conclusions. And I want to say that 2 days ago, I pointed out that there is a tension between this territorial order and the liberal international order. And I suggested these were in tension with each other. And the state territorial order is kind of reassuring to populations. It makes them feel kind of safe. This is my home. This is how I get kind of my identity in this space. And by the way, I know my state's looking out for me by using border control to keep me safe. So the state territorial order is kind of encouraged that point of view, but it is also unfortunately encouraged a high degree of unilateralism around international borders that's not compatible with the liberal ideas that are kind of soaring across these physical spaces. And most fundamentally, universal human rights, which is the crown jewel in the liberal international order. And so we are in a situation here in which tensions are manifest constantly at international borders, because we have told people on the one hand that you've got universal human rights. On the other hand, we've exempted borders as those spaces that somehow those rights are not quite as applicable in these areas. And certainly you don't have just an open right, anybody just cross into any other state. That's not been part of what's been included in the liberal international order. But I'm going to still sort of suggest a way to see if we can reconcile, and they're not going to be fully reconcilable, but a way to sort of think of reconciling our commitments to human rights that are universal with our commitments to bordering, which that's where we are in the world. We are in a bordered world. And so it seems to me the one way to think about reconciling that is to take another look at the borders. Take another look at the borders and say, are we really doing all we can to reverse the presumption that these are places where we have exceptional rights to protect national security, where we have the right to overrun human rights in the interest of such security, and often uncritically, by the way. Are these places, in fact, where we can put up walls without worrying how that affects a neighbor or the flows of population through their countries? It's important to me that we see that borders have cooperative roots that can be built on. And they do suggest some important ways in which human rights can be guarded at the same time that border law can be respected. Ultimately, border cooperation is part of the solution to the problem of human mobility. It is to treat, it would be alone though, if that all we did was to deal with the problem of bordering, we would just be treating a symptom, I think, as we all know. That the real difference, the real problem is gross inequality in the world. The real problem, the root problem, is gross access to good governance, safety, life chances. That's the root problem. That's a long-term project. And unfortunately, in a lot of indicators say it's going in the wrong direction. And so what we can do now is that we can, I think, try our very best to work towards that kind of equality. But till then, I think international law offers some tools for improving human rights at international borders. It starts with seeing borders for the fundamentally cooperative institutions that they are. So thank you all so much for listening. I appreciate it. And I hope I see you tomorrow too, and that you have lots of good suggestions. Okay? Thank you.
Thank you very much, Professor Simmons, for this comprehensive, magnificent overview and deep new approach to international borders, and I think very important in terms of our current needs to protect human rights. Good fences make good neighbors, and good neighbors make good fences, and it's kind of an ongoing process, and we need to start along this road, and I hope many would listen to your lectures, and I hope we have a chance tomorrow. I'm sure we'll have a chance tomorrow to discuss it further in the Q&A. So we meet at 1 o'clock after Sir Hersch's lunch at the old library, courtesy of Cambridge University Press. And I welcome all of you tomorrow for another round of discussion of that important topic. Thank you very much.
Thank you.